in his never-ending quest to save democracy, baby boy Hunter appeared before congressional impeachment investigators yesterday for a much-anticipated Q&A session. And actually, from what I understand, and I'm not terribly surprised by this, there wasn't a lot new that was learned.
Right.
That Hunter has been pretty well prepped for this for some time. And what did he do? What you would expect him to do, as he's sort of done publicly, which is chuck up all of his seemingly incriminating messages about the big guy, Mr. 10%. That would be his dad, Joe. He's the president. Chalk all that up to his problems with addiction.
Right.
So that's sort of what I get, the sort of sense I get as to what happened behind closed doors yesterday. But we'll see. There's more to come.
Well, according to some leaks from yesterday's deposition, Hunter was on the Burisma board to fight Russian aggression in Ukraine.
Of course. Of course he was.
But you got to say, I mean, these...
Just like he's given up crack and taken up blow art to save our democracy. No, I got it.
Exactly. Yeah. I mean, lucky for Hunter, the Democratic Avengers were there to defend him. This is fantastic.
What we just witnessed over the last hour was, I think, a deep-sea fishing expedition.
If this impeachment inquiry continues, then Chairman Comer and Chairman Jordan are working with Russia.
They're peddling Russian lies. Basically, the Republicans have become synonymous for Russians. We're talking about someone who is an actual citizen, just a regular schmegular citizen.
Regular schmegular Hunter.
Just a regular schmegular guy.
Republicans are Russians, and the Bidens are regular schmegular Americans. Okay. By the way, I like that AOC sort of accentuated the fishing expedition to deep sea fishing expedition too. Boy, that's
good. Oh, and this
significant.
You got to hear this
expedition.
real quick. Robert Garcia, Congressman.
Republicans apparently hate parents and sons and families that talk to each other by phone often.
Yes. Yep. That's
it. You got it. You nailed it.
All right. So we have that, but Democrats, as performative as that was, were even more performative over the news that the Supreme Court had granted cert on the matter of Trump's claims of immunity in the Jan 6th related prosecution, setting oral arguments for April 22nd and pretty much ensuring that trial will not take place before, or certainly will not conclude before, the November election. Here's a good example. I mean, I'll see your AOC and I'll raise you a Jamie Raskin.
You know, we've seen this court follow Trump's bidding in dismantling Roe versus Wade in a half century of privacy jurisprudence in order to dismantle abortion rights. So obviously we can't put all of our hopes in the Supreme Court. The people need to be engaged and aroused at this point to demand that there be justice, but also to be organizing for the election. Everybody needs to be vigilant.
Yeah, I mean, it's sort of a sanitized version of Chuck Schumer, hey, sending a message to the Supreme Court, we're going to get you. Maybe organize some more thuggery outside Brett Kavanaugh's house or something to tell him to speed it up. For more on all of these legal travails, also discrimination in Leatherneck land, Western Illinois University. I want to talk to him about that. Professor William Jacobson is a clinical professor of law and the director of the Securities Law Clinic at Cornell. He's also the founder of LegalInsurrection.com and president of the Legal Insurrection Foundation. And they also have the Equal Protection Project, which is where Western Illinois comes in. We'll get to that. Professor Jacobson, thanks for joining us again. Appreciate it.
Thank you for having me on.
How did you react to the completely unsurprising news that the Supreme Court was going to take up the Trump immunity claims? And I'm so reacting to the Supreme Court's decision and what that portends, and then, of course, the histrionics associated with that decision.
Yes, I mean, it seems that if all you did is read the mainstream media, you would think this is the most shocking thing that has ever happened. That they are taking up a critically important issue in an election year And really what they're upset about is the timetable might mean there's no trial in D.C. before the election. But it's not surprising at all that they took the issue. Presidential immunity is an area there. I don't think there's been any precedent on that. Of course, nobody's been charged in the past. Critically important issue, constitutional issue. I mean, it's exactly the sort of issue you would think the Supreme Court would want to take up, and they are. And they're taking up whether his actions as president can be prosecuted after he leaves office. And that's like really important. So, no, it's not the least bit surprising that they took it up, just like it's not the least bit surprising that they took up the ballot case, whether Trump's going to get kicked off the ballot. We're waiting for a decision on that. So, yeah, this is all in the normal course of business, but people's hair is on fire because of it.
What about the criminal case or the hush money case out of New York that's going to start in March here? Are you concerned about that one?
Well, I mean, that case is a complete travesty. It really is. There's something very wrong going on in the New York court system between the civil verdict by the judge, which is essentially a business decapitation of Trump, where nobody lost any money. There were no victims. And then this criminal prosecution where they jump through all sorts of hoops to turn an old, out-of-time, stale misdemeanor books and records case into a felony under a novel legal theory in order to extend the statute of limitations so they could get Trump. So both cases in New York, the civil and this criminal, are good examples of what is wrong with our system. And I don't think it's a coincidence that they're both taking place in New York City. But that looks like it's going to trial, and there will be a verdict probably, I would think, by the end of April.
Yeah. Yep. In Fulton County, Georgia, not a good situation when your former divorce attorney looks at text messages that run afoul of the timeline you've given the court and says, "Oh, dang." Basically like, "Oh, you got me." That was not a helpful moment. Fani Willis on the stand was not a helpful moment for Fani Willis and Nathan Wade. I mean, is there any question, really, at least on the merits, that this judge disqualifies Willis and Wade and the Fulton County DA's office from prosecuting this case?
Well, I think there's a couple of different issues there. One is whether there was perjury in court, whether they've been lying, in which case there should be, at a minimum, a bar referral, a disciplinary referral.
Mm-hmm.
Separate question is whether she gets kicked off the case, essentially. It doesn't mean the case goes away.
Right.
It means that she can't be involved. And I don't know. I would have said before this last round where her veracity was called into serious question, I would have said the judge probably wasn't going to do it because the conflict didn't disrupt the prosecution. But at this point, I don't know how the judge in his courtroom can allow this prosecutor, who arguably lied on the witness stand and about her conflict of interest, to continue in the case. I just don't see how he can. Maybe he will, but this last round, as you indicated, dang, they got me now sort of thing, I think is really, really problematic. The electronic evidence contradicted what they said in court, and judge is going to have to deal with that. But I don't see how in such a high-profile case he can allow her to be there. I don't know why anyone who wants Trump convicted would want her there, because that creates a total sideshow. Everybody in the jury is going to know about this. Everybody's going to know that the woman, the lead prosecutor, was having an affair with her assistant. Maybe it wasn't an affair, having a relationship with her assistant with the public money financing it. I mean, is this really what, someone who wants Trump convicted wants?
No, I know. I mean, she should be removed, but I don't want her to be removed because of exactly what you just said. I'm conflicted. It's obviously important to us in Cook County is the action the Cook County judge took yesterday to remove Trump from the ballot, piling on the Colorado and Maine decisions. But I mean, if somebody wants, somebody like another judge in another jurisdiction, because there's so many pending, wants to do the same thing that Cook County judge did yesterday, I mean, it's sort of immaterial because the Supreme Court is going to weigh in on this in short order, and all of this becomes moot fairly quickly when they do.
If they rule that he stays on the ballot.
Right.
So these things will become important if for whatever the reason, and nobody's predicting this, but if for whatever the reason the Supreme Court rules in favor of Colorado kicking Trump off the ballot, then all of these things come into play. Nobody's predicting that. In fact, all of the left-leaning legal commentators who were listening to the Supreme Court oral argument on the Trump-Colorado case were besides themselves predicting 9-0 for Trump or 8-1. So nobody's predicting that, but you never know what happens. These things will all turn out to be, meaningless if the Supreme Court rules against kicking Trump off the ballot in Colorado, because it's essentially the same issue.
So, Professor Jacobson, let's talk about these discriminatory scholarships at Western Illinois University. What's going on there?
Yeah, so at Equal Protection Project, equalprotect.org, we have brought dozens of claims against colleges and universities who have discriminatory programs. And usually they're a one-off. We find one or we get a tip, more likely, about one at a particular university. Well, we did get a tip about Western Illinois University, and we started to look into it, and we found 16 of them. We found 16 scholarships there that discriminate on the basis of race, discriminate in favor of, they use various terms. Sometimes they say black students, sometimes they say minority students, the different terms, but basically they discriminate on the basis of race. Some of them also discriminate on the basis of sex. I think there's one that's only open to black females. And so we have filed a complaint with the U.S. Department of Education over these openly discriminatory programs, and the sheer number and volume indicates to us, at least, that there is a serious problem at Western Illinois University, because in all the dozens of these we filed, we've never found more than one or two at a university, and we found 16 here.
So some people may look at this story and say, well, wait a second. Like, what if I'm a successful black entrepreneur and I want to endow a scholarship in my name or my family's name at Western Illinois University, specifically for black students to have the opportunities that I had, then how would that be? Well, what's wrong with that? How would that run afoul of the law?
Sure. Well, this is a public university, which is administering the scholarship. It doesn't matter where the money came from. It's promoted on their website. It's promoted to their students. It's administered by the school, and it is open only to students of the university. That being the case, there's this thing in the 14th Amendment called the Equal Protection Clause, which is that every person is entitled to equal protection of the laws. We had a Supreme Court decision last summer about that in the context of admissions to a university. So it's against the Constitution. A public university cannot do that. It doesn't matter where the money came. It also violates the U.S. civil rights laws. It violates Illinois law. You can have whatever intention you want. You can endow whatever scholarship you want, except you can't endow a scholarship that discriminates on the basis of race or on the basis of sex. And I think one of them even discriminates on the basis of sexual preference and gender identity, because it's not open to students who are not LGBTQ. So this is a problem there. I don't know what's going on at Western Illinois. Maybe they just lost sight of things. Maybe this accumulated over time, but they need to get a handle on it, and they need to comply with the law.
Right. The key there is that they're a government institution. So, this is why something like the United Negro College Fund or other private scholarship organizations are under a different legal regime than is a government institution.
That's right. And there is a case pending out there. It's up in the 11th Circuit Court of Appeals about whether even these private scholarships can discriminate on the basis of race, not based on the U.S. Constitution, but there's actually a civil rights law post-Civil War that prohibits discrimination in contracting. So, but that's a different legal issue. So whether a private foundation can do this is an open legal question at this moment in time. But there's no open legal question that a public university cannot do this.
He is Professor William Jacobson. He's clinical professor of law and director of the Securities Law Clinic at Cornell. He's also the founder of legalinsurrection.com and president of the Legal Insurrection Foundation, as well as the Equal Protection Project. And again, that website, professor, is
equalprotect.org.
equalprotect.org. Professor Jacobson, thanks as always for joining us. Appreciate it.
Great, thank you.
Thank you. And he joined us on our turnkey.pro answer line.
It's news, opinion, insight. This is Chicago's Morning Answer on AM 560. The Answer.
This is Carol Platt-Liebau for townhall.com. Last week, Laken Riley, a University of Georgia nursing student, was